submissions. The brutality of this murder, 13 shotgun blasts, again, one through the back of the father's head, one to the mother at point-blank range as she lay dying on the ground, and then through the kneecaps after each one was dead, in order to stage it as a mafia killing. We have described that repeatedly in words, and there's never been an objection to that. There was never an objection to the fact that these crime scene photos were viewed very publicly and put out publicly for millions of people to see. Now, at the hearing that we had the other day, we described again in words the brutality of the killing, not to do it gratuitously, but because we believe that the rehabilitation, that the coming clean with all the lies starts with the murder itself, the brutality of it, the fact that the Menendez said that they had nothing to do with the murder for 6 months, the fact that the Menendez brothers staged it as a mafia killing, and you have to describe exactly how it was staged as a mafia killing in order to make the point. Now, what we did at that time is we showed a crime scene photo as part of our presentation. What we've apologized for is that we did not alert the defense and the Menendez family that in addition to doing what we had done many, many, many times in public, which is to describe the brutality of these killings in words, that we were also going to show an additional photograph. We've apologized for that. We've made it clear that if we ever were to do it in the future, we would provide advance notice, by the way, not just to the Menendez family, but to anyone in the courtroom who might be seeing this photograph in order to prepare them that if they want to leave at that moment in time, they can. We will not be presenting a crime scene photo as part of the next 2 days resentencing hearings, and that's our position on this issue.
How do you respond to
I'm not at this point, I'm not going to be commenting on the contents of the comprehensive risk assessment.
DA, can you talk about how there's arguments that you've conflated resentencing with parole here? Judge Jessek's ruling last week said that the analysis had nothing new last week. The insight standard you keep citing is more relevant to parole than resentencing. The report you're asking for the continuance around today was also prepared for the purposes of parole resentencing. So can you just explain, do you disagree with that interpretation?
We do in part, and what we disagree with is that the focus of both parole and the focus of a resentencing hearing is on rehabilitation and the risk of danger to society. Those are the same standards that apply for resentencing as apply to parole. And the California Supreme Court has weighed in, as have other California courts, on what constitutes both rehabilitation and what constitutes a risk of danger to society. One of the factors that they have focused on has to do with insights, exhibiting insights into the full breadth of your conduct, and they have said explicitly that if you have minimized your criminal conduct, which we believe the Menendez brothers have done, by perpetrating their self-defense defense, and never acknowledging the lies concerning saying that their mother was going to poison the family and their father was a violent rapist, that when you continue to minimize your criminal conduct, you do not exhibit full insights into it. If you do not exhibit full insights into it, you are not rehabilitated. If you are not rehabilitated, then you continue to constitute a risk of danger to society. So that's how those topics are actually not conflated. They overlap. The same standards that will apply in the parole hearing to rehabilitation and risk of danger to society are the same standards that will be considered in the resentencing hearing.
Are you planning any witnesses of your own today?
I'm sorry?
Are you planning to call any witnesses of your own today?
I believe today the defense will be calling witnesses, yes.
Who we expect to hear from?
Team received word of the CRA on Tuesday, filed that motion late Wednesday. Why the gap? Why not alert the judge on Tuesday when you first started were able to read what was in it?
So after we received the report, we had not asked for that report. The report came to us somewhat unexpectedly. We didn't actually know the parameters around that report and what could be released, what could not be released, whether or not the court had received it or not received it. It took us a little bit of time to actually figure that out over the next day, and at the point we realized that the report could be received by the court if the court requested it of the governor's office, that's when we filed our continuance to alert the court that if the court wanted to do that, we were prepared to allow the court additional time to do it. And by the way, the court's own choosing, if the court either chose not to receive that report or didn't need additional time, we were prepared to go forward with the resentencing hearing.
The judge has received the report.
I do not know one way or the other.
Do you believe the father molested them, though? Do you believe?
So my personal belief on sexual abuse is not actually relevant for these resentencing hearing. The central defense in the Menendez case was not sexual abuse. The central defense, the perpetrated, concocted defense, was actually self-defense. And that's not Nathan Hochman saying that. That is Erik and Lyle Menendez testifying to it. As we've shown in our papers and in the courtroom proceeding, both Erik and Lyle Menendez, when asked the question, was sexual abuse the reason that you killed your father and your mother, the answer was no. What was the reason you did it? Because we believed our parents were going to kill us that night. Their attorney confirmed that as well. Leslie Abramson has said that sexual abuse does not justify murder. It never did, and it never will. That's a quote from her own attorney. So the focus today, I believe, will be on the self-defense defense as part of the lies that the Menendez brothers continue to tell to this very day.
For what you've seen of the risk, there's some conflicting information. So the state has said only one component of that risk assessment has been released and that it's also subject to change. So it's essentially a draft. They said the full version would be released on June 13th. But what I'm hearing from you, if I'm hearing correctly, this is the comprehensive risk assessment. So what exactly is it that you're opposite?
So the document is called a comprehensive risk assessment. It's not called a risk assessment and then I added the word comprehensive on top of it. It's actually called a comprehensive risk assessment. It has been provided to, at this point, ourselves. I don't know if the court has actually asked for it and received it. And again, the governor has indicated that it is part of the information that the parole board will receive. Again, it is not the final or the only document that the parole board will receive and rule on. It's probably subject to change over the next 60 days or so. There'll be additional information, I am sure, that the Menendez brothers and their counsels will bring to the attention of the parole board to additionally consider. So again, to the extent it has facts, useful facts, one way or the other, that either justify resentencing or don't justify resentencing, the prosecution does not fear those facts. We just want every part of the factual picture to be before the judge when he makes his decision.
From what you've read so far, the judge is not accepting your motion to delay. Resentencing is going forward for today. Did the judge say anything about that risk assessment? Is that going to play any part in the next 2 days?
We'll find out in court today what the judge decides on either asking for the risk assessment or his analysis of the risk assessment. I don't have that information right now.
From what you've read so far,
I think that he will rule on it momentarily. I would imagine it'll be probably one of the first things he rules on. And again, we made it clear in our own motion that the request we are considering is basically for the judge's benefit, not the prosecution's. We're ready to proceed. And if the judge is ready to proceed, we'll start calling witnesses, or the defense will start calling witnesses today. And if the judge then needs some additional time to then review the comprehensive risk assessment or even ask more questions about it, we made it clear that the prosecution is willing to certainly give the judge any additional time he needs.
From what you've seen of the risk assessment so far, does it back up your claims or your arguments in your belief?
I won't be commenting on the contents of the risk assessment at this point.
Can you tell us who you expect to call in this hearing? I know you said you might not present today.
The defense will be calling witnesses today. We'll make a decision after the defense calls witnesses whether or not we need to call any. All right, thank you all very much. I appreciate it.
You got it?